Welcome to On the Chain.
Right.
Where's the rest of the story? Is that it?
This is it.
This
That's
is the
all we're
headline?
going to talk. We're just going to talk about the headline.
I don't see anything else. Everything's a blank slate.
It's just
hell?
a blank slate. That's it.
My
Fill in the
gosh,
dots.
What in the hell?
You get to write the story for yourselves. You kind of imagine what would go along with this headline. So Charlie Gasparino over here said, crazy crypto ruling, judge shaking up the $1 trillion market. Now he goes into crazy. I'm trying to figure out, and I kind of read through the whole thing, and really what I want to do is start at the bottom of the article and then work our way through it all the way to the top. Because as he kind of summarizes the article, and here's how he ends the article. So in the meantime, the crypto industry will have to live with one of the more bizarre and dangerous court rulings I've ever seen in covering finance for 3 decades. Right. So that's kind of how he ends it. But if we get back into, let's go to the top of his article here. And he says here, we're taught to revere the judiciary because driving legal truth is supposed to be heady stuff. We probably shouldn't, and you have to give credit when credit's due. And in Judge Torres's case, when it came to this Ripple case, the SEC v. Ripple, the way that she provided outcome and ruling on XRP, and then how Ripple sold it versus how individuals bought it, it was pretty spot on. And Deaton has some commentary on this as well, so we can get into that. So here I don't like the way he's writing this, mainly because the outcome provided clarity for XRP, right? And it pushes the and she has some statement that, in fact, in her comment, that Ripple was selling XRP in the early stages to institutional buyers, and that would be deemed a security. Now that still has to be decided in court. And so that court case will, potentially continue down the road. And so when it comes to XRP, as we all know, she said it's not a security. So what was confusing to Gasparino? Why is he saying it's so wacky? Here he says, Judge Torres, of course, didn't say those exact words, but you don't need to be a legal scholar to decipher the upshot on her weird decision that's
Jeff,
roiling the $1.2 trillion crypto market.
Jeff, let me just break in there for a second. The reason he doesn't understand is because he's not a legal scholar and he doesn't understand the interpretation of Howey and the 4 prongs. He's like Bill Hinman and said, well, I just thought any of the prongs once. It was a security if any of the prongs fit. So he's like, you don't have to be a legal scholar, Charlie. You have to have an understanding of the Howey test and the law. And Torres faithfully interpreted this, Jeff. Sorry to interrupt you there, but this is shocking. Like he's talking about you don't have to be a legal scholar.
Right. And we sat down and deciphered the whole thing, or broke down the case with John Deaton, and John Deaton was pretty satisfied with the, overall outcome, and explained how the judge kind of came to, specific decision. We have, an entire hour plus on that. He gets into how, and some of the things that he's saying is, yes, do we need to have, clear regulation? Yes, we do. And guess what? It's moving in that direction. But here he said it involves the digital asset token XRP utilized and sold by a crypto company named Ripple. And it's further proof that judges can be acutely witless. More important, that Congress needs to take crypto regulation out of the hands of the judiciary ASAP and fix this possible transformative business before it moves to places where there's more rational regulations like China. Now, he brings up a good point. Should the judiciary be the one settling this, or should it be through a congressional act? Of course, Congress should act on this, but they haven't. And now we have a ruling on it.
And I recall somewhere in, maybe it was December of 2020 or January of 2021, where you and I said that this might be the quickest path to clarity.
Correct.
Check, correct. Everyone laughed. And I got a little nervous when I thought it would last about a year. Then we hit 2 years, then we hit 2.5 years. Honestly, I never thought it would have taken that long. But Jeff,
Right.
this article is all over the place. It makes zero sense what he's talking about.
It really is, and I'm not, I'm not going to reference any of other Judge Torres's other rulings because they could be completely off base. But this one and this outcome, so he gets into it further to get a better understanding of this mess. Let's go back to around 2012 when Ripple, no relation to the cheap wine people used to drink back in the day, unveiled its cross-border payment system that uses blockchain tech to facilitate faster transactions. It's basically a crypto version of Swift used by banks to transfer money across the
It is
globe.
not.
Right, exactly. So
Douchebag.
understanding that Swift is a language, is a messaging service platform, and part of RippleNet is the messaging service. The other part of RippleNet provides full streamlined settlement of currency and beyond using the ODL. So yeah, RippleNet is much more than what Swift is. I guess if you want to dummy it down to the basics, you could say that, but he should put a statement in there and put a little caveat that in fact Ripple and RippleNet provides full settlement, and it's a modernized version that one little component of RippleNet is what Swift is. So he gets into this chip. The trouble began around 2017 when Ripple, which also created the digital coin XRP, another relatively
They did
incorrect
not.
fact. So
Another fact, another proven misconception, wrong.
right, began
was
selling
open-
tons of it.
God almighty, this is just a train wreck.
Some some proceeds went into financing Ripple's platform execs who had XRP sold as well. Some of these sales were to big investors, so-called institutions, company officials like its CEO Brad Garlinghouse and its founder Chris Larson. And the company itself also sold additional XRP to small investors, not directly, but pumping this stuff through crypto exchanges. Pumping it through crypto exchanges.
It's the sad part of this thing. What really highlights is that when you think you're doing something really clever, and all you're doing is demonstrating how little you know about this is so many different subjects. Like you could just Google like who created the token XRP, and it would say that it was originally created as open coin, right? I mean, Jeff, it's like it can take 5 minutes to Google it. You can just do a little bit of research on this. He doesn't understand the difference between, the whole idea that Torres got this right was on a blind bid, which he basically said is a secondary market. You didn't know who you were buying it from. The Howey test, there has to be an expectation of profit from whoever you're purchasing it from, right? How did you know who you're purchasing from? And those 3,000 notarized statements from the XRP community stated that they didn't even know who Ripple was. They didn't give a crap who Ripple was. They probably still don't care who Ripple is, But the whole idea of this, like these are just easy concepts. And what I don't understand is that because somebody has such a strong belief that they're willing to suspend any sort of like logic and reason and faithfulness to upholding listen, Gary wanted litigation, enforcement by litigation. He got it in a big way, and it took a big loss. And nobody, including the Bitcoin maxis, can handle this. They don't even understand how this is great for the crypto world at large, Jeff. That's the best part.
And well, it's even more shocking that Gasparino's been around the block. It's shocking that he's been prodding the XRP community even after the victory. It's shocking that he wrote this article without knowing the facts in their totality. It's shocking that he probably didn't read the case. He didn't read the outcome of the case in its entirety, go through everything. He hasn't, put any comparative with the Howey test. He hasn't read into the full use case that is Ripple. He hasn't read into the formation of Ripple and the formation of XRP to differentiate. And maybe he has, maybe he hasn't. But why are you writing this article that's published in the New York Post and getting in? And he tries to put a little bit of funny to it and putting the spin. And he's trying to be a little bit of this, a little of that. And, so here Chippy gets into the cost of doing business. The way security laws traditionally work, when a company like Apple does something like this via private placement or selling pre-IPO shares, an IPO or a secondary offering of stock, they go to the SEC and file a bunch of stuff about their operation, depending on the type of sale. IPOs demand more disclosure than private placement. this can be time consuming and expensive, but it's a cost of doing business. So the way I'm reading this, Chip, is he's basically saying that the way Ripple sold the XRP is essentially like Apple going pre-IPO and releasing shares, and that those shares would still be deemed a security.
I don't know what he's talking about, to be honest with you. I
Right.
think Charlie lost the plot a long time ago.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.